person we debate on this insolvency and bankruptcy bill amendment in the backdrop of the suicide, a very unfortunate suicide of somebody who's been called the coffee king of India. And I've just seen this article by Bloomberg which says the death of India's coffee king should actually be a lesson in our country in how not to allow industry to die in this country. It's very unfortunate that this is a bill, of course, which I support. There's no question. But it's very unfortunate that a bill like this should continue to grow and expand in our country. It doesn't bode well for our country that insolvency and bankruptcy law should expand, because that's not the way you reach a $5 trillion economy or the world's third largest economy, which is the dream of the present government. It's a law in the making. It's one of the more salutary laws, there's no question. It's had very limited success so far. In fact, some of the largest cases of insolvency and bankruptcy, Supriya Sule spoke about the Essar Steel case, which has gone round and round in circles and has had so many ups and downs and so many swings and roundabouts over more than 600 days, with so many rounds of litigation that I think apart from lawyers, I don't know who else is benefiting in this entire exercise. So therefore, despite that, we find that the NCLTs are completely, the NCLTs are completely overburdened. At present there are 14 benches of the NCLTs in the country, of which one is yet to be functional. The Kolkata bench, in fact, which has the maximum number, I think, of these cases, are overburdened as judges, and these benches are sitting in rotation both in Guwahati as well as in Cuttack. So therefore, it's imperative to boost the judicial strength of the NCLTs in order to achieve some of the goals of time-bound resolutions which have been set by this government. Many of the provisions that have been brought about are salutary, there's no doubt about that. But I think we will find many more amendments will need to be brought in as time passes and as wisdom dawns upon us. There is some clarification that needs to be sought or maybe given by the government with regard to the conflict between the IBC and other statutes. Because SEBI, for instance, seems to have moved the Supreme Court recently to appeal an order of the NCLAT, which said that Section 14 of the IBC has overriding powers over the SEBI Act. And this prevents SEBI from selling off assets of a defaulting company, as a moratorium is imposed under Section 14 of the IBC. Similarly, it seems IBC is also in conflict with RERA, which is the Real Estate Regulation Act, a very important piece of legislation again. The Supreme Court has declared that home buyers are financial creditors now, so therefore there can potentially be a case where proceedings are initiated against a real estate developer, both under IBC and RERA, and of course the Consumer Protection Act as well. So multiple proceedings under multiple acts. I don't know how the government plans to bring about some sort of resolution as far as all these conflicts between various acts are concerned. The government definitely has done a good job by protecting the MSME interests by drawing out an exception to Section 29A, allowing MSME promoters to take part in the bidding of assets, which is otherwise not allowed for the larger operators. To continue on this track, I think the inclusion of MSMEs in the Committee of Creditors should also be considered by the government, because they can be the MSMEs should be treated as a separate class of creditors to protect their interests, because they need protection from the government. And they, as I have said before in this House, really form the vast bedrock of employment that is provided in this country. They are the ones who actually provide the bulk of the investment, as well as also the bulk of the employment, which is a crying problem in this country. Apart from that, I certainly want to draw the attention, and I have done that on a personal level with, for instance, Mr. Anurag Thakur, the Honorable Minister of State, about the manner in which the agencies are mindlessly going after some of these companies in terms of red flagging accounts, in terms of calling accounts fraud accounts, in terms of ordering forensic audits for the asking. Now, this is being done because bankers are being drawn into the net by CBI and ED for simply being nominee directors on companies. You know, I mean, I don't want to mention names here, but one of the companies, the Economic Times said, 580 people have been charge sheeted. You will need a full football stadium in order to carry out a trial. and possibly the next 40 to 50 years, again with nobody benefiting except lawyers. And there, nominee bankers have been charge sheeted. Now, a bank asks a individual to be a nominee director on the board of a company. And if that company fails, if you're going to bring that nominee director under the pale of criminality, and there's not one, not two, dozens, and this includes, and may I say this with great respect, one of our ex-chief election commissioners today, Mr. Tandon, is charge-sheeted. One of the highest constitutional authorities simply because he was a nominee director on a board of a company. If this is going to be the manner in which the government agencies are going to be allowed to operate, I say this with great respect, and I have said this before, I think one of the great mistakes of UPA 2 was the manner in which they let these rogue agencies, or rather they let these agencies go rogue. Let me correct myself. They let the agencies and individuals in the agencies go rogue. Anybody and everybody was allowed to be charge sheeted. Anybody and everybody was roped in, whether they were guilty or not guilty. And by the way, almost 99.9% of those cases, there have been acquittals. There has not been a single conviction in any of those cases. Simply public time and money has been wasted. So therefore, I urge the government not to spread panic among bankers, not to, because at the end of the day, bankers and bureaucrats are the bedrock of how this country is going to go forward in economic motion. And if you spread this kind of panic, that if you put your pen to signature, if you even agree on the bank's decision to make you a nominee director, that you are going to be charge sheeted and face the next 25 years in a court of law and then eventually be acquitted, as has happened in 2G, as has happened in the coal scam. It's happened in dozens of cases. I think UPA 2 saw a very sorry end to their regime. And that was simply because there was no political direction given in these matters. And the political hand said, do what you like, you're free to do what you like. So perhaps the obsession with honesty is a good obsession, but that must be tempered with pragmatism. I support this piece of legislation and welcome any future legislation of this kind that the government brings in to tweak these laws to help industry. Thank you very much.
Thank you. Honourable Member Shri Jasbir Singh Gill.